Good afternoon, everyone, and welcome to this meeting of the Standing Committee on Justice and Human Rights. C'était un grand plaisir d'être rejoint par Madame Sanssouci qui remplace Monsieur.
Great pleasure to have Mr. Sanssouci with us, who's replacing Mr. Rankin for our study of Bill C-78.
Of this very important bill with the Honorable Jody Wilson-Raybould, our Minister of Justice and Attorney General, who is testifying, and she is joined with us by two distinguished representatives of the Department of Justice, Madame Nathalie Drouin, I have to read the title, Deputy Minister of Justice and Deputy Attorney General of Canada, and this time we only have one Laurie, Laurie Wright, who is the Senior Assistant Deputy Minister. So, Madam Minister, the floor is yours.
Well, thank you, Mr. Chair, and of course, thank you to all of the members of this committee for the opportunity to present on an incredibly important bill, Bill C-78, an act to amend the Divorce Act, the Family Orders and Agreements Enforcement Assistance Act, and the Garnishment, Attachment, and Pension Diversion Act, and to make consequential amendments to another act. I am incredibly proud of the work that our government has done to improve the lives of Canadians experiencing separation and divorce, in particular children. Bill C-78 is the cornerstone of this work. Federal family laws have not been substantially updated in over 20 years. Over the past 2 decades, families have changed considerably, and so has our justice system. Our government understands that there is much to be done in order to improve federal family laws and family justice systems so that they better meet the needs of Canadians. Separation and divorce can be incredibly difficult for families, especially children. For most Canadians, their only interaction with the justice system will be through the experience of family breakdown. 2 million children in this country are impacted by separation and divorce. With this bill, we are taking concrete steps to help parents come to a timely and lasting resolution of their disputes with a primary focus on what is best for their children. Bill C-78 advances 4 important goals: promoting the best interests of the child, addressing family violence, reducing child poverty, and improving efficiencies and accessibility to the family justice system. I will briefly address each of these in turn. Promoting the best interests of the child is a common theme tying together all policy initiatives reflected in this bill. The primacy of the best interests of the child is a fundamental principle of Canadian family law. Bill C-78 will further entrench and bolster this principle. The bill includes a non-exhaustive list of criteria for a court to consider in determining the best interest of the child, including elements such as the child's needs, given the age and stage of development, the child's relationship with people in his or her life, especially parents, but also others such as grandparents, the child's culture and heritage, including Indigenous heritage. The bill also proposes a primary consideration. Any plans for the child's care, any allocation of time or responsibilities, and any imposition of terms or conditions in a parenting order would have to be made on the basis that the child's physical, emotional, and psychological safety, security, and well-being must be considered above any other matter. The bill also removes the archaic language of custody and access that the Divorce Act currently applies to parents' relationship with their children. The Ontario Court of Appeal and several associations of family justice professionals have highlighted that these labels focus more on parents winning and losing rather than on what is best for the child. Instead, Bill C-78 embraces the principle that children are individuals who have their own needs and rights, and therefore proposes clear definitions of parenting time and decision-making responsibility. Child's rights organizations have been particularly supportive of this proposed change. The bill does not contain any parenting presumptions such as equal shared parenting. Rather, it focuses on what is best for each child. A presumption would force courts to impose one particular parenting arrangement on every family, unless a party could convince the court otherwise. This would mean that judges would have to be actively involved in more cases to hear evidence to displace the presumption, which could increase conflict between parties and place additional and unnecessary pressure on already overloaded family courts. Moreover, in cases involving family violence, abused spouses may not have the financial or emotional resources to prove to a judge that the presumption would not be in the child's best interests. Fundamentally, a presumption would detract from the focus on the best interest of each individual child, which the bill aims to promote. We know that each child and each family is different, and children deserve to have their own unique needs and situations considered. That is why we have taken this approach. Bill C-78 will still preserve the maximum contact principle that a child should spend as much time with each parent as is consistent with the best interest of that child. This would not be a parenting presumption. However, it would be subject to the primary consideration of the child's physical, emotional, and psychological safety, security, and well-being. And for the first time ever, we are defining family violence in the Divorce Act. In Bill C-78, we have introduced an evidence-based definition of family violence that provides a non-exhaustive list of different forms of family violence and is designed to evolve over time to capture additional behaviors and patterns as our understanding of family violence expands. This definition explicitly mentions coercive and controlling violence, which social scientists believe to be the most dangerous form of family violence. Again, this definition is designed to evolve over time to capture additional behaviors and patterns as our understanding of family violence expands. The bill also proposes best interests of the child criteria to help courts draft a parenting order where there has been family violence. These criteria will also be subject to the primary consideration that the child's safety, security, and well-being would be considered above all else. The bill introduces other measures to keep family members, especially children, safe. The non-removal provisions will help prevent child abduction in appropriate cases. Another provision will remind courts of the option to order supervised parenting time to promote safety and reduce children's exposure to conflict. Our government has committed to lifting Canadians out of poverty. In addition to initiatives like the Canada Child Benefit, we are supporting middle-class families by helping to ensure families facing separation and divorce have the support payments to which they are entitled. We know that families are especially financially vulnerable in these circumstances. Single-parent families have a significantly lower median net worth than do couples with children and tend to have lower levels of employment. We also know that single-parent families are disproportionately led by women, and so these financial pressures contribute to the feminization of poverty. Receiving a fair and accurate amount of child and spousal support can help prevent these families from experiencing poverty. Addressing family poverty helps to target child poverty, which we know can have long-lasting impacts. Bill C-78 therefore proposes several important changes to make it easier for families to receive the support to which they are entitled. A significant impediment to families receiving child support that they need is the parties' failure to disclose incomes, despite their obligation to do so. The bill will amend Family Orders and Agreements Enforcement Assistance Act to allow the federal government to provide information from a party's tax returns to a court, as well as other provincial services, such as maintenance enforcement services and provincial child support services. There are currently billions of dollars in unpaid child support payments in Canada, the vast majority of which are owed to women. And with this bill, we are giving provinces, territories, and individuals more tools to ensure that those obligations are being paid. The bill includes rigorous privacy protections to support this change. If this information were released to a court, it would have to be sealed and kept inaccessible to the public. The bill's fourth priority is increasing access to justice and improving efficiency. Bill C-78 will provide parents with more options to resolve family law disputes. While the courts may be the best route for some families, others may benefit from out-of-court dispute resolution processes as a lower conflict, more expeditious, and lower cost option. These processes enable parents to play an active role in crafting their own agreements, which increases compliance and makes for better agreements that are uniquely adapted to each family's situation. However, Bill C-78 does not make family dispute resolution mandatory. Situations of family violence or power imbalance can make some mediation or dispute resolution processes inappropriate. What Bill C-78 does is require that lawyers must now inform their clients of all their options, both in and out of court, so that families are sufficiently informed of all available options. In conclusion, Mr. Speaker, Bill C-78 includes a number of other important changes that I'm happy to discuss further. But for now, I would like to thank all the members of the committee for their meaningful work, the meaningful work that you will undertake in studying this bill, and for the ongoing dedication of making Canada's laws as strong as they can be. Through Bill C-78, we have an important opportunity to make a real difference in the lives of Canadian children and families. Separation and divorce are among life's most challenging events, and I am proud that Bill C-78 proposes significant ways to make these processes a bit easier for all involved. Thank you, Mr. Chair.
Thank you very much, Madam Minister. We really appreciate that. And we have the Minister until 4:30. Colleagues, we can probably get through 2 rounds of questions as long as we stick to our times. So I won't take up any more time. We'll go to Mr. Clement. Mr. Clement?
Thank you, Chair, and thank you, Minister, for being available for this important bill. I did want to convey to committee members, I have 2 notices of motion that I will read out now. We won't debate them now, as I understand it. I don't want to cut into the Minister's time, but I did want members to be aware of them. The first one says that the committee invite the Minister of Justice and Attorney General of Canada to appear to answer questions with respect to any rules, precedents, or procedures related to the invocation of cabinet confidence to prevent the disclosure of information as requested by counsel in a trial process. That's obviously relating to the Norman issue. And my second notice of motion is that pursuant to the order of reference of Wednesday, October 24th, the committee consider the supplementary estimates A before the reporting deadline set out in Standing Order 81(5), and that the committee invite the Minister of Justice and Attorney General of Canada to appear in view of this study. So just want to get that on the record and proceed with a few questions and answers, if you don't mind, Minister. First of all, not concerned, but note that there's quite an increase in the judicial system when it comes to self-represented litigants. That's true of many courts, not just the family court, of course. Bill C-78 is now 4 times longer than the previous act. So non-lawyers are going to have difficulty, I would say, digesting all of that and making sense of all of that. And so I just wanted to get your thoughts, Minister, on how this will impact on case management and a further bogging down of a family court system, which I think you will agree is somewhat overburdened right now.
Well, thank you for the question, and it's a pleasure to have you at this committee. In terms of further bogging down the family justice system, I'll answer that in terms of a number of respects and tools that we're working on to provide information and resources to not only self-represented litigants, but individuals, legal agents, and lawyers that are involved in the family justice system. Of course, our department is going to work very diligently to provide information and materials to be able to provide the public on the various aspects of Bill C-78. We are in the process of working on that, and we'll do so in conjunction with our colleagues in the provinces and territories who are also responsible in terms of the shared administration of justice in terms of family courts. Beyond that, I'm really pleased that in the previous budget we were able to receive endorsement for 39 new judges that will comprise an expansion of the unified unified family courts in 4 jurisdictions, which will help to streamline the process. But again, with introducing changes to the Divorce Act and the other acts, we are updating and modernizing the Act. We have been doing so in concert with my colleagues in the provinces and territories, and I actually look forward in the next week to sit down with my colleagues to discuss Bill C-78 and the tools that we're going to be making available.
So given the, I must say, poor track record on judicial appointments of this government to date, how can Canadians be sure that these promises will be fulfilled?
Well, I would say that I'm incredibly pleased with the track record of our judicial appointments, appointing 235 plus or appointments or elevations since I became Minister, of extremely meritorious individuals that sit in the superior courts across the country that reflect the diversity of the country. We are continuing to work very diligently with the judicial advisory committees to process applications, and I would say to you, my colleague, and to all of the other members around this table to encourage individuals, if you know individuals that qualify to be judges, to put their applications forward.
It's not, the issue is not the applications, it's the actual process by which you decide and determine. But let's leave that and go on to the children, Minister, because you did highlight the importance of protecting children and their well-being, and how that is obviously of primary importance. I do want to comment, though, that this committee has just been through Bill C-75, and of course that bill does propose summary conviction options for very serious crimes, including the abduction of a child under the age of 14 and participating in activities of a criminal organization, forced marriage, marriage under the age of 16. These are all hybridized offenses now. So how do you square what we saw in Bill C-75 with your rhetoric today about children's protection?
Well, appreciate the question. I completely disagree with the characterization of rhetoric. Bill C-78 is a very substantial, significant piece of legislation that seeks to update the Divorce Act, which hasn't been updated in 2 decades, as well as to ensure that we are putting in place factors that will enable and assist a judge to determine what the best interests of the child are, and factors around domestic violence and relocation, all of which are to protect and put a child first. In terms of Bill C-75, which is our criminal justice reform bill, I am very familiar with the 136 offenses that we're seeking to hybridize in that piece of legislation. And I will say, as I've said many times before this committee, but particularly in the House, nothing in terms of the hybridization of offenses changes the fundamental principles of sentencing. Serious offenses will still be prosecuted in a serious manner, due and having regard to the proportion of the gravity of the offense and the degree of responsibility of the offender. We are not reducing sentences. We're providing prosecutors with the necessary tools and discretion they need to proceed in the manner that is most appropriate in the individual circumstances of a particular case.
Yeah, Minister.
Sorry, you're over 7 minutes now.
Okay, thank you.
Thank you very much. We're going to go to Mr. Assassi. Mr. Assassi.
Thank you, Mr. Chair. Thank you, Minister.
Thank you.
It's great to have you back, and thank you so much for this incredible bill. As you rightly noted, this is the first substantial update of the family law regime we've had in over 2 decades. So just going over it, it was incredible to see all the changes that are being made. Now, my first question has to do with the fact that this particular proposed bill will incorporate the Hague Conventions, more specifically the 1996 Hague Convention and the 2007 one. In addition to that, finally, we will come into full conformity with the UN Convention on the Rights of the Child. So would you mind sharing with us how significant this is?
Well, thank you for the question. And in terms of the last convention that you mentioned in terms of the rights of the child, we're pleased in terms of being able to assess the best interests of the child, that one of the factors for a court to consider or individuals to consider in terms of the best interests of the child is to actually consider the child's interests and the child's views in appropriate circumstances. That brings us into compliance with what has been asked for in that particular convention. In terms of the other two conventions, this Bill C-78 does provide us and with the steps to be able to accede to those other two conventions, as you say, the 1996 Hague Convention on the Protection of Children and the 2007 Convention on Child Support. As you probably know, these are significant conventions, and we will be able to move forward with signing on to these conventions. In terms of, sorry, Mr. Chair. Just briefly, the 1996 convention sets out rules to clarify issues such as what countries' courts can make decisions about parenting arrangements for a child and what laws should apply when a child lives in one country but also has close connections to one or another country. The 2007 convention is an international agreement that provides a low-cost and efficient way for people to get family support across international borders. This enables us to move forward with respect to these two conventions.
Thank you very much for that. Now, a second aspect of this bill, which is really important, is promoting access to justice and, to the best of our abilities, ensuring that we're alleviating pressure on the family court system. Now, one of the things this bill does is it encourages Canadians to resolve divorces and divorce-related issues by way of alternative dispute resolution. Now, one of the concerns is that the mechanism for ADR isn't necessarily readily available all across the country. So what would you say to that particular concern?
Well, I would say, first of all, that I'm really encouraged by, obviously, the member having reviewed our bill very closely. In terms of alternative dispute resolution, of course, this is something that we're encouraging, also putting a positive obligation on lawyers and other individuals to recommend alternative dispute resolution processes where appropriate. We have, and working with the provinces and territories, made financial commitments to the provinces and territories. In budget 2017, we committed $16 million per year for family justice services on an ongoing basis. $15 million of those dollars goes to provinces and territories for their family justice activities, and $1 million of that money yearly goes to support innovative programming in the provinces and territories.
Excellent. Thank you so much for that. Now, the last question I had is some people are quite a bit concerned that this particular bill does not incorporate the equal parenting presumption. Could you kindly inform us why it was your decision not to do so?
Sure. Great question, and one that we've had many times. The central premise of Bill C-78 is to put the child first. We purposely did not put any presumptions in terms of equal parenting in this legislation because of that very fact. Children are different, family situations are different, and we wanted to ensure that the primary consideration was around the best interest of the child, not consideration around what's in the best interest of a particular parent. So we provided many different factors around what could be determined and weighed around best interest of the child, and to have a presumption would put individuals in the place where they rebut that presumption in favor of one parent or the other. And what we want to ensure that we do in every way possible is to ensure the focus is on the best interest of the child.
Thank you very much. That was very helpful. That concludes my questions.
Thank you very much. And you were perfect. You hit it right at 6 minutes. Madame Sans Souci, c'est à vous.
Merci, Monsieur le Président.
Thank you, Chair. And thank you, Madam Minister, for being here with us. And thank you so much for having brought in this bill, which has been much anticipated for some time in the legal profession and by parents as well. I have 6 issues to touch on, and I wonder whether you would accept via our clerk, if we run out of time to get through them all, to allow me to send you the questions and that you or representatives in your department send me answers. Thank you so much. Much appreciated. I would like to pick up on my colleague's question about the Convention for Children's Rights. At present, it's only mentioned in the preamble. Would you accept that this be amended to have it included as a primary reference, the reference to the Convention, be included in the text of the bill itself?
Sorry, thank you for the questions. And yes, to the 6 issues that you'll bring forward, we're very happy to provide comprehensive answers to them. I would say at the outset, we are open to any proposed amendments that come from the committee, but I was just conferring with Lori, my official, and it's not our practice to put the text or the substance of the convention within the body of the legislation. But put and place the principle of that convention, which we have in the factors around the best interests of the child to take into account the child's desires, the child's interests.
Well, I didn't mean including the entire text, but refer to that convention within the bill, not merely in the preamble. That was more my suggestion. But let me pick up on the next issue. The Canadian Coalition for the Rights of Children recommends more legal training about the whole process of deciding what the best interests of the child, and that this be based on the committee dealing with children's rights, giving extra ideas about how to give effect to this principle. I would like to hear how the government intends to proceed to improve awareness about this principle, which is important to the rights of children.
And I think it touches on a previous answer that I gave around what our department is going to do and the commitment that we have to make sure that we are using the resources, updating our website in terms of the tools that are available around family law and helping to explain the provisions that are contained in Bill C-78, hopefully when it becomes law, to provide those tools to practitioners to explain various factors around the best interests of the child. As you will note from the legislation, there are many factors there to assist practitioners, lawyers, and assist courts in interpreting the law.
The child has rights when their parents separate. In a conflict between the parents, it could be useful to allow the child themselves to be represented, should there be a need for that representation by a legal counselor, to put forward the child's right, without, of course, reducing the parents' access to legal aid, not to break that legal aid time down into 3 times. In fact, UNICEF Canada recommends taking the child's opinion into account based on criteria other than the child's age. We feel that would really make of the best interests of the child a primary consideration in divorce. So would you agree to have the state look into seeing that the child be represented?
Premise of, first of all, the whole premise of C-78 is to ensure the best interests of the child are paramount and central to any considerations. I know that this representation of the child and the child's interest was something that was raised by a colleague of yours. This falls within provincial territorial responsibility around representation, but again, I suspect that this is an issue that will come up when I have conversations with my counterparts in the provinces and territories, but rest assured, in terms of the best interests of the child, this is central to this legislation, and it's the central premise that we uphold.
Vous avez parlé.
You mentioned how important it is to deal with child poverty as one of the aims of this bill. via, for example, ways of making it easier to ensure that child support is respected. It's clear that it plays an important role in reducing the impact of divorce on the parent who does have custody, but there might be limits on the efficiency of this approach. For example, for families who in low-income situations. I've got 3 questions about this. What percentage of parents in Canada do not respect child support orders? Do we have that data?
Actually, I think that we do have that data right off the top.
Mais ça peut faire partie des informations que vous nous transmettez.
That lack of compliance could be some of the information you give me later. If that's all right with you, you can give it to me later. Because all said and done, how much can we address poverty among children by ensuring that more compliance with child support orders if the parent at issue doesn't really have much income to begin with? That's my concern. You know, if the parent has very reduced resources, it's all very well to have child support orders, but if they can't pay them, so do you have anything on this?
To provide additional tools in this legislation. There is, as I said, billions of dollars of outstanding child support that has not been paid. So we're providing, by way of this bill, if it becomes law, the ability to gain access to income tax returns, to have a better idea of the amount of money an individual has, and to be able to collect and garnish income potentially. But as you say, that doesn't answer all family situations where individuals live in poverty. That's why our government has sought to take other measures to address poverty among that children live within through the Canada Child Benefit, through various other means. This is poverty with respect to children, and having the ability to be raised in a comfortable manner is a broader issue than that can be addressed in this piece of legislation. But what we're seeking to do in the changes that we're proposing in Bill 78 is to provide the tools that we can to enable as much as we can that billions of dollars of unspent or unpaid child support to be paid.
Thank you. Et Madame Sans-Souci, votre temps est...
And Ms. Sans-Souci, your time has elapsed, but if you send in a question, we will certainly see to it that they get to the Minister for a response.
And thank you, Minister, for coming in today and talking about this very important legislation. Minister, this is a topic that comes up very often amongst my constituents, especially those that are women, that are finding it difficult to really even start divorce proceedings or to get themselves out of a bad marriage or a bad home just because of the financial implications. Can you help us understand how Bill C-78 would really help those that are in the middle class and those that are working hard to join it to be able to go through this process, to be able to liberate themselves and their families and get themselves out of those bad situations?
Well, thank you for your question, and I guess the premise of your question is that in your riding and in ridings across the country, Canadian families are incredibly different. Individuals find themselves in difficult situations, and as I said in my opening remarks, individuals' first and possibly only interaction with the courts is through the breakdown of a marriage, separation, and divorce. So what we're seeking to do is based on advocacy over many decades, is to ensure that where there's a child of a marriage, that we put the best interest of the child of that marriage first in terms of parental orders. We've also, for the first time ever in Bill C-78, seek to amend the Divorce Act to put in to account for particular circumstances where there is family violence, to put a definition of family violence into the Divorce Act, as well as factors that will determine and assist in determining the severity of the family violence, of which we know many women are subject to family violence that needs to be taken into account, and especially in terms of the relationship with the children, and to the affordability question, in terms of efficiencies and in terms of access to justice, we're trying to encourage alternative dispute resolution processes, as we talked about earlier, processes that take us out of the courts that are, for the most part, lower cost for individuals that seek to find parenting arrangements in a less combative environment, but also a less costly one. And we do know that, as I said also in my remarks, that there is a feminization of poverty. 96% of the unpaid family support orders are for women, and they don't receive those orders. And we need to make sure we can do everything to provide the necessary tools to, one, gain access to the financial information of a parent who owes those support orders, to make the correct determinations for what those orders should be, and additional tools like being able to garnish a parent's wages to be able to comply and reduce as much as we can the billions of dollars of outstanding child support payments.
Thank you, Minister. You touched briefly on the changed definition of family violence, which I believe is from the British Columbia's definition. But still, there's a 2013 report that says that the courts still too often underestimate the consequences of family violence or being abused, being exposed to abuse. How will the family violence provisions set out in Bill C-78 change the court's approach to that, if at all?
Well, thank you for the question. And what we've sought to do broadly in C-78 is to provide as much information to enable courts and other legal agents to be able to make determinations. And we have taken the lead of other jurisdictions that have proceeded ahead of us in this regard. And you mentioned British Columbia. Another jurisdiction, I would say, is Alberta. We have, in terms of the definition around family violence, we have also put in place a list of the types of conduct that may constitute family violence. And in terms of that list, it's not an exhaustive list, but it provides a bit more detail or various situations that the court could consider in making the determination of a situation of family violence, and being able to determine what is in the best interests of a child in those particular situations.
Minister, do you think that this statutory change could really impact the occurrence of family violence within Canada, or do you think that other measures are also required?
Well, I believe in terms of family violence and violence generally, the more we are aware and the more we provide individuals, the court system, with the necessary tools to, one, be able to identify when it has occurred, understand a definition of family violence, that it goes beyond physical violence. It could include financial violence, coercive behavior, and understanding various situations and having examples or a list of factors around what violence actually means, can mean, and that list is, as I said, is evolving. This definitely helps. These discussions, these lists of various types of conduct have been discussed over the years, have led to changes in legislation in provinces, and we're wanting to ensure with the changes to the Divorce Act that we elevate and raise the issue of family violence as a really substantial challenge that comes into play at marriage breakdown, separation, and divorce, that needs to be considered to ensure where it occurs that the best interests of the child are provided for. That's what we've sought to do in this legislation. Are there other ways that we can address family violence? Absolutely, but we have, beyond Bill C-78, but we have sought to provide a list and to ensure that we elevate this conversation, because we know that this is an incredibly destructive factor that happens, and children find themselves in the middle of those conversations. So we want to make it as easy for children as possible to provide the best parenting order for them.
Thank you for this important bill, Minister.
Thank you.
Thank you so much. We'll move to the second round of questions, and so that the Minister is finished by 4:30, I just want to remind everyone in this round, the Liberals and the Conservatives have 5 minutes each, and the NDP has 3 minutes each. So this is a different order. So we start with Liberal, Conservative, and then NDP. Mr. Boissonnault.
Thanks very much, Mr. Chair. Minister, thank you for being here, and thank you for making 230 judicial appointments on your watch, 100 in 2017, and the most of any Minister of Justice in over 20 years. And I think it's also worth congratulating you that over half are women, 8 are Indigenous, 20 are from visible minority communities, 13 identify as LGBTQ2, and 3 identify as persons with disabilities. So bravo. That's a lot of work, and it's nice to see that people will be sitting on the bench for many years. I also want to thank you for understanding in this legislation, though it's not explicit, that families come in all shapes and sizes and configurations. And I went to my iPhone once and wanted to text David an image of what our family could look like at some point. He's Jamaican. There's no emoji that exists for a white man and a black man to have 2 kids. So I said, well, maybe someday when we have kids, we'll just send the image of our family into Apple, and they'll give us a new emoji in the future. Oh. Right? And so the gender-neutral language is really appreciated, and so I thank you for that and for understanding that LGBTQ families. And the sad thing is, look, when we got equal marriage, it also means we got equal divorce. So we've got people whose relationships don't work on the same sex side of the ledger as well. And so that also means that families need to be supported, and the courts need to understand that same-sex couples are going to be coming forward to them. So I just want to thank you for the work of this bill. I hear about it at the doors, and I get correspondence on it. So from a Franco-Albertan perspective, I know that you've done great strides as Minister to make sure we have functional bilingual Supreme Court justices in our nomination process. And in my own province of Alberta, organizations have received over $1 million to support the important purpose of making sure that Francophone Albertans can access divorce proceedings. So could you chat a little bit more, share with us more information on that?
Well, thank you for talking about our judicial appointments. I really appreciate it, and I would again underscore that families come in all shapes and sizes, so thank you for your comments around that. In terms of official languages, and I know that there's other members of this committee that are concerned about access to justice in both official languages, that is a priority for me, and it definitely includes being a priority in terms of the family justice system. With that in mind, we have, and I wrote this down because I suspected you would ask this question around bilingualism. We have expanded the scope of our support programs for these purposes, for bilingualism, through the Canadian Family Justice Fund. And one of the fund's priorities is to extend the reach of the Family Justice Program services and information to meet the needs of diverse and underserved populations, including official languages minority communities in Alberta and other places. And in budget 2018, our government also increased access to justice in both official languages by more than 25%. And in addition to that, finally, I would say that, again, we are working with the provinces and territories, recognizing that provinces come in many different shapes and sizes, and justice being a shared responsibility. We're working with the provinces to ensure access to justice as much as we can in both official languages.
Merci, Madame la Ministre. Je sais que mes collègues...
Madam Minister, I know that my good friends, my colleagues who are members of the French-speaking jurists of Alberta will also be very thankful for your work in this file. I saw among the nominations, the appointments rather, more justices who are both Anglophone and French, fully bilingual. Thank you.
Prioritization of family debt comes into this bill, and how the understanding of where different debt levels come for families, because I understand that's also an important consideration in this legislation.
The debt in terms of priority around debt, in terms of Crown priority.
Yep.
the Crown, in terms of debt collection, the Crown would come first, as it is considered a debt to all Canadians. But then after that would be the collection of debt in terms of family support payment or child support payments.
Mr. Cooper. Thank you, Mr. Chair, and thank you to the Minister for being here. Let me first of all say that it's encouraging that the best interests of the child is a centerpiece of Bill C-78. The best interests of the child is something that is well established in Canadian family law. Bill C-78 under Section 16 provides that only the best interests of the child shall be considered in respect of orders applicable to children in family situations. Now, while that's encouraging, I want to follow up with the line of questioning that Mr. Clement had asked, and it relates to how do we square, on the one hand, Bill C-78, which puts the interests of the child first, with Bill C-75, that hybridizes a number of serious indictable offenses, including offenses that relate to crimes against children. And Mr. Clement made reference to kidnapping a minor under the age of 16, as well as the offense of kidnapping a minor under the age of 14. I want to raise the issue of the hybridization of individuals who breach long-term supervision orders. These are individuals who have received sentences of more than 2 years. They're deemed to have a substantial risk of reoffending. The offenses for which they were convicted of involved a range of sexual offenses, often against children. They're considered to be a serious risk of reoffending, and so serious, in fact, that they can be subject to up to 10 years, subject to an order that imposes a whole series of very strict conditions. We're really talking, Madam Minister, about the worst of the worst when it comes to offenders who are at risk of offending again, often against children. So my question is, how does that square with putting the interests of the children first by hybridizing the offenses related to those breaches, which are often the first sign that these bad actors are going back into their criminal, their history of violence and escalation towards that. It's a serious public safety concern.
Just going to note for the record, I'm not taking from your time. I'm stopping the clock for a second. But that question, I waited to the end of it to see if it related to Bill C-78. It seems to relate to how a principle in C-78 squares with C-75, which is not what the Minister is here to testify about today. I'm going to ask the Minister if she wishes to respond to that question or if she prefers not to. I mean, it's up to her.
Oh, well, Chair, I do want to take issue with your...
I'm happy to respond to that question.
Yeah.
Again, I'm fine to respond to that question, and as the member noted, the best interest of the child is the basic premise of Bill C-78, and I'm really pleased to hear right around this table that everyone embraces the best interests of the child, and I hope that the study from this honourable committee will proceed expeditiously to ensure that we update our divorce laws. In terms of the members' comments around Bill C-75 and the hybridization of offences, I will go back to my previous answer to your honourable colleague, our honourable colleague. The answer is the same. In Bill C-75, it is a very bold piece of significant legislation that seeks to address delays in the criminal justice system. This is a piece of legislation that was developed very closely with my counterparts in the provinces and territories, and the comprehensive nature of the legislation will reduce the delays in the criminal justice system. One of the pillars of the reform in that bill is around the hybridization of offenses. And I'll say again, hybridizing offenses in no way changes the fundamental principles of sentencing. Serious crimes will continue to be prosecuted in a serious manner. Prosecutors, through the hybridization of offenses, will be given the tools or the ability to use their discretion to proceed in the manner that they deem appropriate given the circumstances of a particular case. But again, in no way are we reducing, diminishing the serious nature of offenses. Offenses will be, once a conviction is put in place, will be sentences will, a court will determine the sentences based on the proportion of the gravity of the offense and the degree of responsibility of the offender. So again, it does not change the sentencing principles.
Well, it's my time.
Well, actually, your time is actually expired.
Well,
it's 5:17. So we're going to Mr. Fraser because your time expired. But I'm sorry, Mr. Fraser.
Thank you very much, Mr. Chair. Thank you, Minister, as always, for being here with us and answering our questions on the relevant bill that we're studying. I'm glad to hear, I guess, that the Conservatives don't seem to have any substantive questions to ask on Bill C-78, and I'm assuming then that they'll be supporting the bill. So getting to the substance of this bill, I would like to acknowledge and thank you for highlighting in your remarks the fact that the terminology that is often used in family court cases relating to custody and access are problematic because they do pit oftentimes the parties against one another in a win and loss sort of atmosphere, and that is not in the best interest of the child. And so I applaud you, Minister, for making that highlighted in your remarks and in the bill, and by ensuring that parenting orders are reflected and the terminology updated to ensure that really the true best interests of the child are at stake, but also the parents see that that is really what is important in these tough decisions, is what is best for the child. One of the items in the non-exhaustive list that can inform a court on what the best interest of the child is, you mentioned heritage and cultural considerations, including Indigenous children of Indigenous backgrounds. And can you expand a little bit about why that would be important in ensuring those considerations are taken into account by a court to determine the best arrangement for a child?
Certainly, and thank you for the comments around the change in terminology. I will say that the change in terminology from stakeholders, from individuals that we've talked to, this presents a significant change in terms of how we proceed. Many provinces have been out in front on us and other jurisdictions in terms of the change of terminology. Again, as you said, moving from a win or lose situation to one that focuses on the responsibility of parents and parenting orders, decision making and parenting time. And it actually moves beyond the premise that children are possessions and that children should be the center in terms of separation and divorce and the considerations around that, which is why we sought to, as you talk about, put in place criteria or factors around what is in the best interests of the child or what should be considered. And I was pleased to be able to put the child's cultural, linguistic, religious, and spiritual upbringing and heritage, including Indigenous upbringing and heritage, in as one of the factors to be considered in terms of the best interests of the child. As we said, children are different. Children have different identities and identify with particular groups, parents, religions, and we want to ensure in a breakup of a marriage or divorce that that identity, what the child feels and where he or she is tied to is taken into account. It's one of the factors to be considered, but it's an incredibly important factor. I suspect many individuals around this table, including myself, who identifies very closely with an Indigenous heritage. It's incredibly important to maintain the child's well-being.
Thank you. And I'd like to follow up on that as well with the fact that other people in the child's life can be their relationship with the child can be taken into account in determining what is in the best interest of the child, such as a grandparent or another person. Could you touch on what this bill does for people other than the parents that are close to the child, that have a relationship with the child, and how that's taken into account in determining an arrangement that works best for the child?
Yeah, absolutely. In our legislation, we have put in place a provision that provides for contact orders for a grandparent or somebody that is close to the child that contributes to the well-being of that child. So an individual on leave of the court can apply for a contact order. We hope in separation and divorce that parents will not have such an acrimonious relationship wherein they can't determine the individuals that are important to that child and to provide the ability of those people to have access to the children. But in cases where there is a significant relationship between a child and a grandparent, or a child and an uncle, or a child and a longtime family friend, there is provision to enable a contact order.
Thank you so much. Mr. Clement?
Thank you. Just on C-78, obviously you've made reference, Minister, to changing the descriptors from custody to decision-making responsibility as an example. And, you know, I think I would hope that makes a difference, but being realistic, parents will continue to battle over custody and control of their children, sometimes tooth and nail. I mean, that's the unfortunate reality of the situation. Human nature being what it is. So can you just, I mean, I know what the intentions are here to lower the temperature and to focus the bill, but really, is there any real change we're expecting in terms of how parents behave in this system when it comes to their kids?
Well, I appreciate the question, again, because we do not know, nor can we know, a situation of an individual family in an acrimonious reality where there's a battle over the child. What we have sought to do in Bill C-78 is to legislate what courts have told us around best interests of the child. We've sought to, again, change the terminology to move beyond a win-or-lose situation. And to your point, and in discussions that I've had, individuals that have been involved in family law and are family law advocates actually have spoken to me about changing the terminology is a start to actually changing the culture of family law situations and the resolution of those situations. We have other jurisdictions that have changed the terminology, but again, to your question, we're seeking to try and do everything we can to provide factors and as much information for courts to consider for individuals in alternative dispute resolution situations, to move beyond the focus on individual parents to focus on the children. And what we have sought to do by way of providing factors around best interests of the child, providing a definition for family violence and factors around that, to relocation and setting a framework, was to ensure that in any of these discussions, the child's interest is
a little bit limited on time, so I am going to.
You asked me a question. I was just answering it.
I know, but now there's another 10 seconds gone. Let me. I think it is important that this bill send the right signals to parents and to children, which is why we not only raised on this side of this committee Bill C-78, but we were talking about signal creating in Bill C-75 as well, and trying to square the two, because the signal of this bill is the children. But the signal of the other bill, C-75, was lessening, and I know you say it's not lessening the sentences, but allowing the opportunity. And, you know, the justice system takes its signal from you, Minister. And the signal that you have sent is that these serious offenses are going to be treated less seriously. And my colleague, Mr. Fraser, and others on the other side changed their mind on the terrorism, and the reason they gave was that's a serious offense. Well, kidnapping a child is a serious offense. You were quoted in the National Post, I believe. Oh, Mr. Boisano was quoted in the National Post.
Point of order, Mr. Chair.
So
this is not relevant to the bill that the Minister is here to discuss today.
I already connected it to Bill C-78.
Point of order, it's not relevant. The discussion that's
I already connected it to Bill C-78.
Characterization of what Mr. Fraser actually said about terrorism and genocide. You have the floor, Mr.
So
Clement.
in the minute that's left, can you try to help us understand why it's okay under C-75 to treat children's offenses less effectively, but it's not okay under C-78?
I'm happy to respond to that, and I'll respond to it in a different way that I responded to the hybridization of offenses. I completely disagree with your characterization of the signal that I am seeking to send with Bill C-75 and Bill C-78. The signal that I am trying to send with Bill C-78 is to ensure that we do everything we can to address the delays in the criminal justice system. I am not sending the signal that there are offenses that are less serious, offenses that warrant a less punitive measure. With respect, that is the signal that you are trying to send. You are mischaracterizing the hybridization of offenses in Bill C-75. I think it does a disservice. What we are trying to do is to ensure that prosecutors are provided with the necessary tools. With respect again to my honourable colleague, you are mischaracterizing the hybridization of offences. I believe it does a disservice to Canadians, and you are working very diligently to create fear in Canadians where the fear should not exist, because we are not reducing sentences in Bill C-75.
Thank you very much. Thank you, Mr. Clement. La dernière question, last question, is 3 minutes. Ms. Sanssouci, if that's okay. Madam Sanssouci.
Merci. Avant de...
Thank you. Before I put my question, I will touch on a problem that was brought up by my colleague, Mr. Fraser, the change from custody to parental activities. The Barreau de Québec suggests that we look at the actual cases and that we ensure that there's full clarity to avoid any useless litigation. So here's my question. Earlier, you told us about Indigenous children and their circumstances. We know that the risk of acrimonious divorce with violence is higher for Indigenous children than for non-Indigenous children in Canada. So I would like to know to what extent C-78 will assist Canadians of Indigenous origin who are dealing with family violence.
Well, again, this is a more fulsome question that I would be very happy to have with the member. But in terms of family violence, with respect to the Indigenous family or Indigenous community, again, we have, in terms of the Divorce Act, what is proposed is to introduce a definition around family violence and a list of considerations or examples of what family violence means. This not only applies to Indigenous communities but other communities. I'm not 100% familiar with the recommendation from the Barreau de Québec, but I'm happy to consider that and again respond in a fulsome way to your 6 issues. And I'm not sure if that was one of your 6 issues, but maybe there's 7. I'm happy to respond to 7.
Effectivement, parce que oui.
Indeed, because yes, you're right that it's not necessarily about, I think that a family violence intervention program is good for all Canadians, as you say. But as you've also pointed out, we should have programming that's culture-specific, that should be offered to Indigenous communities across Canada. And if we have such programming to stop violence, then it will work better if it's community-based.
With you more, we do have programs at the Department of Justice that specifically look to providing Indigenous the Indigenous Justice Program is a program that we provide dollars that to Indigenous communities and organizations across the country to address specific issues that seem to befall Indigenous communities through various measures of restorative justice initiatives, looking at addressing and collecting data in individual communities. So there are measures within the Department of Justice and programs that assist in community-specific challenges, but also providing resources to come up with solutions to address them.
Puis comme vous l'avez mentionné, c'est aussi dans tout.
As you mentioned, much depends on cooperation with the provinces, especially if, let's say, the child is to be sent to another family and the divorce is such that the child can't stay with either of the parents. There's a lot of work to be done with the provinces to ensure that the children not be taken too far from their own milieus and face further difficulties.
Intervention, and the great thing about having amazing public servants is that mine wrote me a note about the Victims Fund that the Department of Justice also administers and releases significant dollars every year to assist with addressing the rights of victims and ensuring that we're responsive to those rights. But again, happy to talk with you further.
Thank you very much, Minister. Your testimony was very helpful to the work of the committee. We really appreciate it. Madame Drouin, merci beaucoup. Ms. Wright, thank you very, very much. I really appreciate all of you being here today. And we'll take a short pause while the Minister leaves, and we'll resume in 4 minutes. Thank you. Meeting suspended.
you.